Advertising Law, a guide to the code of advertising practices, a practical guide, I'm told, to the code and practices of the Advertising Standards Authority. The author is lawyer Gail Schimmel and joins us today. Gail, a very warm welcome to you. First of all, let me just put this into some sort of context. You worked for the ASA. It might be useful as well to tell us what the ASA does.
Okay, so I was the head of legal at the Advertising Standards Authority, which is the body that deals with complaints about the content of advertising. So my speciality now, I've left the ASA, I'm an independent consultant now. My speciality is the rules about the content of advertising, and taking complaints to the ASA, how to deal with the ASA, how to have a successful match in the ASA, how to defend complaints in the ASA.
It implies that there are problems sometimes when people take complaints to the ASA. Is that true?
Absolutely. I think the reason I wrote the book is that marketers seem to think that this is a throwaway function, that they can lodge a complaint in the ASA, that it's not complicated, and a lot of lawyers think it's not complicated, and they don't do it properly. So they're unsuccessful, and then they think there's something wrong with the ASA because they've been unsuccessful with their complaint. There's a big need for marketers to understand the ASA better, to be lodging better complaints, to be dealing with the processes better, and a big need for lawyers to be doing it.
Typically, where do marketers fail then in that respect?
Badly drafted complaints, not explaining what the cause of complaint is properly, identifying the wrong clauses of the code. You know, the code seems like a very intimidating document. It looks thick and big, but it's actually the part, if you know how to read the code, it's quite easy to use and it's quite easy to follow, and it's a lot about gut feel, but it's knowing which clause is correct, and then if you're the marketer producing the material, knowing when you're in a danger zone and knowing what the precedents are around that danger zone. So I'll have clients who come with a storyboard or with a produced commercial saying, we know we can't possibly run this. And I'll look at it and say, it's not really a problem. And then the reverse, that there's something where they don't even think to call a lawyer in to look at it, and it's got a glaring problem in it.
Typically, where might there be a breakdown here? Is there a commonality of complaints, for instance, in the way in which they're handled?
There are two aspects of complaints. They're consumer complaints, they're competitor complaints. And a consumer complaint will be the mother grandies a lot, but also some genuine problems that consumers pick up in advertising. But those will be more the things around offence and discrimination. Sometimes it's a little bit about, I don't believe that this is true. Often it's about service issues. Those ones are easier to deal with in a sense, except for the offence ones where you've got to really understand where the line is drawn, what precedents there are in the ASA. The ASA has a reputation of being a mother grandie, before we talked about stripping the joy, but in fact they actually are quite liberal in their approach and knowing where to fit in with that. So that's the challenge there. Competitor complaints are the big one.
So this will be one advertising agency objecting to something else that another advertising agency has done?
Yes, or more typically these days, and this is interesting, it's become the marketers themselves more. It's the agencies are less involved, and I personally would like to see a change back to the agencies being more involved. The agencies taking more responsibility for the material and for the working of the ASA. It's an industry body. The agencies should be taking more ownership of that.
Typically, Gail Schimmel, when a complaint is lodged, what's the process after that then? The sense I get is it's fairly long and onerous, isn't it?
It's not really. If you lodge a complaint, within the ASA it will first be assessed to see if it's vexatious, frivolous, or has a basis. So,
who does that?
There are a team of people called assessors who do that. And the assessors look at it and they go, is there advertising material attached? The person has complained about a naked woman, and they watch the ad and they see that actually it's a naked ankle. And then they'll go back to the person and say, sorry, ankles are fine. You've got to find a woman before you complain about a woman. And I think I don't have the latest stats, but it's something like 80% of complaints are thrown out at that level. Then the complaint, if they have the material, there's a valid complaint, then they identify the clauses. If the complainant hasn't, they send it to the advertiser to respond. Between 48 hours for substantiation, 3 days for competitor complaint, 5 days for consumer complaint. You have to respond. You respond, And then typically the consultant dealing with the matter will draft a ruling and it will go through the process of checks. The ASA aims to have it all done within 30 days. They don't always, they have been very good recently. At the moment, the complaints have dropped this year and they're pretty much on the ball, and especially if it's a bit of a sexy one. I had the Salsi humping dog.
Yes, the humping
that
dog.
was dealt with very quickly because it's interesting for them as well. So it's fast. It's maybe not as fast as we would like it to be, but it's still faster than a court.
All right, the book is called Advertising Law, Guide to the Code of Advertising Practice. Lots of humping dogs and naked ankles. Gail Schimmel, thank you very much.
Thank you, Jeremy.